The Expropriation Act has caused chaos throughout South Africa, and not simply from the perspective of those that were challenging its promulgation, but also the regular South African who has now witnessed US policy changed towards South Africa insofar as foreign aid is concerned and them ceasing this foreign aid. Now, I'm not a politician. I cannot comment on how this came about and what discussions were had preceding this. There have been reports from the White House, however, to say that not only was it the Expropriation Act that brought this into play, but also South Africa's stance towards Israel. A conversation that I can have with you, however, is what challenges are being brought at this current moment in time towards this Expropriation Act. The most recent being a challenge by the DA in our courts relating to, comprising of two aspects. Number one, the procedural aspect. So how did this act come about? Were the correct voting mechanisms followed? Did the provinces correctly have mandates? And this is a big argument in the DA's papers that comprise the majority of the content of the application. But another argument being brought by the DA is in respect to the time frame that a person has to approach a court in the event of them not agreeing that expropriation is appropriate or wanting the court to determine what price needs to be paid for such expropriation. Now, there is a time frame that is suggested in the Act, and in the DA's papers, they acknowledge that if this Act is to come into play or remain in play, that a time frame would be necessary so that there are no lingering matters that wait 5 years or 10 years for a resolution. So rather resolve these matters sooner rather than later. However, the time frame is quite short, given that it's only 180 days. But the primary issue is the ambiguity over when this time frame begins to run. And this is one of the primary arguments that the DA has against the substantive nature of the Act, is the fact that it does create ambiguity, and one does not actually know when their rights arise or when the timeframes arise in order for that time period to start counting. This, however, in my view, is not a permanent attack towards the Act that would result in the Act being done away with and never coming back into force. Both these attacks, unfortunately, may only have temporary relief to those looking for this relief, in the sense that if it was procedurally flawed, the way that the Act was brought into play, then a correction of this procedure would simply result in the Act being promulgated again. Similarly, should these sections be struck down or amended by the court for being ambiguous or not properly advising the citizens of their rights, these clauses can be amended in order to adequately address these rights, or the rights that they intended to address. So it will be an interesting case to see how the DA fares with the courts, and whether this is going to be a decision by the courts to declare the Act unconstitutional or simply have the Act amended in order to better cater for the aspects that are being brought up by the DA.